sequence would be that the Constitution of India, in its application to the state of Jammu and Kashmir, would stand frozen as of January 1957. Therefore, no further development in Indian constitutional law can at all apply, according to you, to the J&K
Exactly.
to the state of Jammu and Kashmir after 1957.
Because Constitution of Jammu and Kashmir
How can that be acceptable?
We may ask this question how, but the question is which provision of the Constitution permits that except 370?
And then Jammu and Kashmir is an integral part of India. Surely the jurisdiction of every democratically elected institution in India is not excluded in its application.
What I am saying here again, let me reiterate.
There has to be then a provision in the Indian Constitution which excludes its application to Jammu and Kashmir, and there is none then according to your argument.
This may be our wish. But the point is, let us look at the provisions of the Constitution. This is what I am saying.
So the very, in fact,
70.
In fact, your argument now cuts across the other side argument.
That's right, no?
Your side argument itself. you're cutting. You're cutting at.
No, but
you see,
there's a difference.
And just look at the second proviso. Just turn to the second proviso.
Yes.
Except with the concurrence of that government. Now the government has been defined, and the argument of your side, some of your colleagues on your side, is government, and the government of the day, council ministers, is different from the Constituent Assembly and the Legislative Assembly.
No,
and here the second proviso does not use the expression Constituent Assembly. It says except with the concurrence of that government. And government has been defined by pursuant to the amendment in 1982. And therefore your challenge or to the dictum in Sampath Kumar is slightly, gets into difficulty because that's the intent behind it.
May I answer that? No? When it says that government, what it means is the government which was preceding the Constituent Assembly.
That's
it can't be any other government because
that's contrary to the explanation.
I'll answer. But kindly bear with me. Why do I say so? After second proviso, there is clause 2. And what does clause 2 say? Whatever concurrence has been given prior to Constituent Assembly has to be placed before Constituent Assembly for enabling it to take a final decision.
What it means is this, that if there is concurrence, because initially when the Article 370 was there, it was Sadr Riyasat and the other council. After that, at that time, if any decision is taken, it will be with that.
Sadr Riyasat continued.
I know, I'm aware, but the explanation which is added is with regard to then the Council of Ministers. The explanation in 1952, which was added by the concurrence of the Constituent Assembly, was with regard to the Council of Ministers.
So there's no difficulty, Lord. We are reading little, with due respect, Lord, we are reading little too much on that. Because have section 27 to 32. It is the Sadr Riyasat elected by the Legislative Assembly who will be the Sadr Riyasat. And obviously the recommendation goes through the Council of Ministers, not otherwise. So the Council of Ministers and Sadr Riyasat as well as Legislative Assembly are all there, elected. And then not by explanation, relying on the explanation to 1952 order, he cannot say in 57, Lord, Constitution does not seize 370. Lord, that doesn't follow because Constitution includes Sadr Riyasat. The continuance of Sadr Riyasat had to be as per section 27, it couldn't be, and that was the fact. So this assertion in Sampath Kumar, Lord, relying upon the 52 presidential order, adding the explanation of elected Sadr Riyasat is not correct. Lord, there are lots of misconceptions. For instance, Lord, in Damanu's case, which I think one of my friends may have cited that. Lord, please read clause 2 in the debates, Lord. Please read clause 2 in the debates, Lord. Lord, may I pay here? Lots of clarification would be there if your Lordship would read the explanation to clause 2 in the debates, Lord. Page 427, the same page. Page 82. Then we come to clause 2. the passages, Lord, paragraph. Then we come to clause 2. You will remember that several of these clauses provide for concurrence of the government of Jammu and Kashmir and the Jammu and Kashmir state. Now, these relate particularly to matters which are not mentioned in the instrument of accession, and it is one of our commitment to the people and the government of Kashmir that no such addition should be made except with the consent of the Constituent Assembly, which may be called in the state for framing of the Constitution. In other words, what we are committed to is that these additions are matters for the determination of the Constituent Assembly. That explains Lordship's question. It may be 1, 2, second explanation, but it comes before clause 2. After reading the explanation in the clause 1D, they come to clause 2. Not otherwise, not the whole reasonable sequence denoted in the Article 370 has no meaning then. And this paragraph includes the second proviso. Clearly. So inferring something different from that word, that government Lord, to me, Lord, as I see it, Lord, it doesn't follow. And then also the next paragraph is equally, Lord, so far as the other thing is concerned. Yes. Just one paragraph, no? Now you will recall that in some of that has been done. That we have read. We have read. Now, Lord, as I said, Sampath Kumar was not, Prakash was not rightly decided. And if your Lordship would just have a look at Sampath Prakash, Lord, that perhaps may eventually conclude my argument. Sampath Prakash is?
Which is the provision of the J&K Constitution equivalent to Article 245 or 246?
They have their own Section 5, which defines the powers of both state and indirectly the Parliament. Section 5 will also have. And this is what continued for a long period of time. If practice is relevant, then this is continued for a long period of time till this order comes. Kindly have Section 5. That is for lots of convenience, volume 2, PDF page. I may first refer to the preamble.
Now see the problem with your argument, because Article 5 says that the legislative and executive power of the state would extend to all matters except those with respect to which Parliament has power to make laws for the state.
Yes.
Under the provisions of the Constitution of India.
Yes.
Therefore, that takes us to the Constitution of India.
No, the reason being
that therefore postulates that the Constitution of India does apply to the state of Jammu and Kashmir.
That overlooks one important factor, and that is the 44th Amendment immediately preceded with the concurrence of Constituent Assembly, where they had elaborately defined what are the provisions of the Constitution of India would be applicable to Jammu and Kashmir. And this Constitution is elaborately based on that 44 order. And therefore, it presumes whatever power has been given to the Parliament under the scheme of things, 44, there what they have indicated is entries 1 to 96 of list 1.
But unless for the purpose of the argument of this side, unless we accept that Article 370 did continue until 2019, there would be absolutely no trammel on the jurisdiction of Parliament under Section 5.
Not, as I said, not
because 5 says except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution.
But there's not
now, under the Constitution, but for 370, Parliament would have the power to make laws with respect to all aspects in List 1 and List 3. Now, if your argument is that 370 goes,
The moment we come to
then
this,
where is the limit on the power of parliament?
I'll answer. It has, Parliament has power to make laws. Now let us fall back to that stage. What was the power given to Parliament at that point of time to make laws? The 44th presidential order, 48th presidential order, which is 1954. It elaborately determines what is the scope of parliamentary jurisdiction, that is entry 1 to 96. Now, if we add entry 97 to that, again, because that is Parliament's power, then what will be the fate of section 5?
But then you've been arguing all this while that these constitutional orders are a matter of constitutional practice. They're contrary to the provisions of they're contrary to the constitutional provision. If we accept your argument and therefore don't look at the constitutional orders, then this is the consequence which follows as a sequitur of your argument, that there would be no restraint on the power of parliament then.
The sequitur is this, Lord, that after the 1954 order, there couldn't have been any other order. And that is why they say in respect to which Parliament has power to make law. Otherwise, again, I fall back on the same theory. Internal sovereignty continued with the state. The constitution ensures that internal sovereignty, there is the whole legislative provision, executive provision, and the judicial provision. What is the utility of that, Lord, if 370 continues to infiltrate? As I said, Lord, add entry 97, that is the residuary power. Then what remains of this? And yet the commitment was there. But all that I am suggesting time and again is, see it in the light of the object of 370. The intent, the object of 370 was only to ensure that no one from outside interferes with the constitution making. That was the object of 370 as the framers have delineated. So therefore, otherwise, Lordship may see, 254 doesn't apply.
Dwivedi, now I think we've really understood your perspective. Can we now wrap up?
Yes. So Sampath Kumar, I've already indicated.
You've already argued Sampath Kumar. So we'll now, there's some people who have to follow now.
It is wrong.
Thank you so much, Mr. Dwivedi. Thank you very much.
There's one aspect, which I want to throw light on, which fell from Justice Coleman. But since there has been repeated exercise of power since 1957 onwards, under 370, therefore that speaks of the validity too. We have to take that into consideration, if I have understood rightly. It can't be that the power was not there yet it was being exercised. Now, there are two authorities which I cite here. And one is which we could call out, because the argument fell from your lordships. Your lordship would permit me. What CJI has to say on that?
What is the proposition you are seeking to
The
make?
proposition is that howsoever long the practice may have been, acquiescence, howsoever long it may have been, that will never confer validity on the provision if the power is not there.
What has been put is not in that fashion. What has been said is if there are two interpretations which are possible.
No, not that. I'm not.
That's what was put to you.
What is being put is the way it has been understood by everyone.
No, as I said, if two interpretations, let's
Now,
not.
at this stage, you say, no, all that has happened over the last so many decades.
That's what Lordship
Nobody
did,
understood the constitution of JNK, nobody understood the
No,
constitution.
that's what
of
lordships did in Lord
What is being
Golaknath.
said.
That's what your lordships did in Indira Sahni. Not in Indira Sahni. No, please recall what happened in Indira Sahni.
All right, we've taken the point that
Yeah,
the constitutional practice will not legitimize a constitutional.
That will not legitimize.
Fair enough. Thank you, Mr. Dwivedi. Thank you very much. We'll now go on to the next, Mr. Singh. Yes, Mr. Siv Singh now.
But there is one decision that we'll also just make a note of it.
Yes.
1961, Supreme Court. AIR 1961 Supreme Court 964. Para 1 and 2.
964.
What is the name of the case?
This is not Amalgamated Coalfields Limited. So just two paragraphs, no?
All right.
1 and 2. It's a constitution bench. Again, they said these are questions cannot convey any kind
Thank
of
you, Thank you, Mr. Dwivedi. Yes, Mr. Singh.
And all that I'm saying, Lord, if two views are possible, let's take the view in favor of the Constitution of Jammu and Kashmir. The autonomy which we had promised, the commitments made.
Thank you, Mr.